Student, I am going to dictate you a legal matter, speed 100 word per minute. Start. Administration of justice. Appellate jurisdiction. Appellate, appellate court can disturb findings and conclusion. Appellate court can disturb findings and conclusion of the trial court, but only for compelling reason. It is by now well settled that the appellate court hearing the appeal filed against the judgment and order of acquittal will not overrule or otherwise disturb the trial court's acquittal if the appellate court does not find substantial and compelling reasons for doing so. If the trial court's conclusion with regard to the facts is palpably wrong, if the trial court's decision was based on erroneous view of law, if the trial court's judgment is likely to result in grave miscarriage of justice, if the entire approach of the trial court in dealing with the evidence was patently illegal, if the trial court judgment was manifestly unjust and unreasonable, and if the trial court has ignored the evidence or misread the material available evidence and has ignored material documents like dying declaration, report of ballistic expert, etc., the same may be construed as substantial and compelling reasons, and the first appellate court may interfere in the order of acquittal. However, if the view taken by the trial court while acquitting the accused is one of the possible views under the facts and circumstances of the case, the appellate court generally will not interfere with the order of acquittal, particularly in the absence of the aforementioned factors. Appreciation of evidence. Courts should not adopt hyper-technical approach. Rather, it should look at broader probabilities of the case when analyzing the evidence available on record. Courts should not adopt hyper-technical approach but should look at the broader probabilities of the case. Basing on the minor contradictions, the court should not reject the evidence in its entirety. Sometimes, even in the evidence of truthful witness, there may appear certain contradictions basing on their capacity to remember and reproduce the minute detail, particularly in the criminal cases, from the date of incident till the day they give evidence in the court. There may be gap of years. Hence, the courts have to take all these aspects into consideration and weigh the evidence. The discrepancies and contradictions which do not go to the root of the matter, credence shall not be given to them. In any event, the paramount consideration of the court must be to do substantial justice. Delay and laches. No time limit specified. Act must be taken within reasonable time. Claim made after 25 years, no entertainable. Insofar as the facts of the present case are concerned, the claim made under Section 87 of the Act was after a period of at least 25 years. This can hardly be described as a reasonable period. There is no explanation for the inordinate delay, and to make matters worse, third party interest have been created through a housing scheme developed on the land in dispute, or in any event on the surrounding land. After a further lapse of 25 years, it is not possible to put the clock back, even if there is any reason to do so, which reason we cannot even visualize in this case. Stop.